So today I'm going to talk about how I helped build a Hub's AI governance program from scratch. 2.5 years ago, I was sitting at my desk revising and reviewing a technology agreement, which honestly is what I spend most of my day doing. And I had a thought that would have a significant impact upon my role advising and counseling my client. The thought was simple. Sometime soon, a significant number of our 21,000 plus employees are going to want to use AI to help them do their job. And we need a policy for that. I'm not Hub's GC. He's the gentleman over there. You're going to meet him today after our 3 o'clock afternoon break. He's a great public speaker and much more entertaining than me. As someone who's written policies in the past, I felt, however, I was in an excellent position to draft a generative AI policy in the workplace. Today, I want to talk to you about what I learned, because I think there is something important to say about the role of in-house counsel and what our role can and should play in the AI revolution. Here's a central idea I wanted to convey or leave you with. In-house counsel are uniquely qualified to lead AI governance, not just react to it. Hub International is the 5th largest insurance brokerage company in the world. If we were publicly traded, we'd be a Fortune 500 company. We operate across the US and Canada, helping businesses that have facilities all over the globe. They trust us with some of their most sensitive data imaginable, non-public information, including their strategic goals, the PII, SPI, and PHI of their employees, and this trust must be respected. With publicly available AI tools proliferating like ChatGPT, it didn't take too much imagination for me to realize that my fellow employees without guidance might be tempted to use these AI tools in serving our clients. Without a policy, without guardrails, without anyone really knowing what was going out the door and how it would affect Hub and our clients. Use of such publicly available AI tools is also a data breach waiting to happen, with potential regulatory violations and lawsuits as a reward. There is no greater truth. Poor execution of governance and compliance obligations puts the businesses we serve and their customers at risk. These governance and compliance obligations all spring from a central source. What does the law require? As such, this is fundamentally a question that we are all responsible for answering. IP ownership, privacy obligations, employment law, federal, state, and foreign laws, contractual commitments to clients. All these limitations converge the moment an employee types a client's name into an AI prompt. A lawyer needs to be in the room, preferably before the first prompt is sent. While you can now ask Claude or another AI tool to draft a generative AI policy and receive it in minutes, 2.5 years ago, it involved a lot more effort. After 3 months of research and 2 months of drafting in my spare time, I wrote a 2.5-page policy. Why so short? This was a deliberate choice rooted in a guiding principle I apply to everything I write. Short, straightforward, and to the point. A policy that no one reads or understands because it's 10 pages long is not a policy, it's a liability. Hub CIO gave me valuable direction. Don't focus on education. Focus on the do's and don'ts. Save the why for the training that follows. This was wise advice. Drafting a policy and the method, theory, and practice of teaching it are different things. What does Hub's policy say? At its core, only use AI tools that Hub has licensed, so your inputs and outputs aren't shared with third parties or used to train your vendor's AI tools. Never put confidential information, PII, PHI, into an unlicensed tool. AI can never be the sole basis for pricing a policy, underwriting one, adjusting a claim, or making an employment decision. AI tools should produce reliable, non-biased, and non-discriminatory output. Any vendor using AI to provide services to Hub and our clients must be approved by our AI governance committee. and I don't know if I mentioned this, but output must be validated by a human before it's relied upon or distributed. A policy alone is not a governance program. While it's a foundation, you will need a structure to administer and enforce it. With the support of our CIO and General Counsel, we formed an AI governance committee. The AIGC is composed of people from across the company, IT, legal, HR, marketing, compliance, operations, not just lawyers, not just technologists, because AI touches everyone and everything. We needed and wanted all of these perspectives. The AIGC is a central approval authority for selecting which AI tools Hub will license and make available to employees. Which categories of information, PII, SPI, PHI, can be used in which tools. Employee training and ongoing compliance. We stood up a SharePoint site as a central hub, no pun intended, where employees can access our licensed instance of Quad, get answers to policy questions, and request training. I was always taught that being an in-house lawyer is about protecting assets and limiting liabilities. This project has given me the opportunity to be proactive instead of just reactive. Attending this conference and applying these and other learnings about AI is essential for you to tackle an issue that must be addressed in real time as it affects every department of our respective organizations. Here are 3 things every in-house lawyer must know about AI governance. First, it has already affected your company's relationships with vendors, customers, and outside counsel. Based on the principles that I covered in Hub's GAI policy, I've drafted a client AI addendum, vendor AI addendum, and outside counsel firm guidelines for providing AI services, which I know has been discussed at length earlier today. As a technology counsel, I am leading our efforts in drafting and negotiating commercial agreements from companies proposing to provide AI tools to serve many areas of our organization, including IT and marketing. The issues raised by these companies providing AI tools and your duty to protect assets and liabilities and limit liabilities is never going to go away. Second, the regulatory landscape is moving fast and you must keep up with it. Colorado, California, Illinois, New York, Quebec, Alberta, Ontario. Each jurisdiction where we operate has either enacted or is actively considering AI-specific regulations. Illinois biometric privacy law has real teeth. You cannot outsource this knowledge to your tech team. Third, policy without culture is just a document. The training obligation in our policy isn't bureaucratic box checking. It's a mechanism by which governance becomes behavior. Mandatory completion of required training, annual recertification, retention of training records, a record of relying on progressive discipline when policy violations occur. This all matters when something goes wrong, and eventually something will. You will need to show regulators, courts, clients, and investors that you have had a program in place and enforced it. Our role as lawyers is not to eliminate risk. That's impossible. It's to mitigate risk using common sense governance structures and effective training. A comprehensive policy and the governance structure is not an AI prohibition. It's an AI enablement framework. Hub licensed a secure enterprise instance of Claude from Anthropic precisely because we wanted our employees to have access to a capable AI tool without our company being forced to accept the Wild West risk of publicly available consumer AI tools. If we're going to be valuable leaders, we must embrace the use of AI while helping our clients build the necessary guardrails that encourage them to use this as a difference maker in serving our ultimate customers within the boundaries of the law. The AI revolution is not coming, it's here. And the lawyers who step forward to govern it thoughtfully, precisely, with appropriate humility about what we don't know yet, will define the practice of law in this space for the next generation. Thank you.
That was brilliant. That was brilliant. This one, can you hear me? All right, awesome. So what I boggled my mind is how did you distill all of this as a starting point into 2 pages? Like, how did you like, it's a whole wealth of culture and process and all of this regulatory everything. So this mic, I think, is not working as well. So maybe that one.
I'll give it to you.
Even better. So what's your recommendation, like as a starting point for the folks in the room?
Well, there's what's nice, and then there's what's necessary. And so I started out with what was nice, which actually had that educational component that I spoke of. And I showed it to our CAO, and she said, let's just cover the do's and the don'ts and not talk about the whys. When we do education, when we do training, we can talk about the whys. And that made it a lot easier. And honestly, every single thing I write, as I mentioned when I was talking a few minutes ago, every email, every sentence, I ask myself, do I need that word? Is it an effective communication? Do I need that word for it to be an effective communication? And in my view, less is more. My paragraphs are often one sentences in emails because I know someone's going to be reading this on their phone potentially. And I need this to be an effective communication, something they're going to remember. And I teach a writing course to law students. So I'm thinking about this all the time when I'm talking to them, trying to teach them on how to write effectively as attorneys. But shorter is better always, 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 always. That's why they call them mini series.
I love it. Well, thank you so much, Michael. And I can't think of a better, shorter is better. I think that if you're looking for what's the one key takeaway quote for the little QA we're going to do later, that might be a good one. Well, thank you so much.